All right. Good day, everyone. And thank you for joining today's Ask Me Anything, where we answer your questions about cannabis legalization in New York. We do this every Wednesday at 4:20 p.m. New York City time. I'd like to welcome back those of you who have joined us before. And for those of you who are joining us for the first time, I hope you'll make it a regular occurrence. My name is Jeffrey Hoffman, and I am an attorney here in New York whose legal practice focuses entirely on cannabis. If you would like to contact me, you can do that either here on LinkedIn. I welcome all connection requests, or you can contact me at my email address, which you see at the bottom of the screen, info@420jurist.com, which I guess you might say makes me the 420 jurist. And as the 420 jurist, I will be answering your questions, roughly half from the list of questions I've gotten from previous Ask Me Anything sessions, and half from questions which you post in the comments here today. And I've actually gotten quite a few good ones already in the comments from folks before the session started. So if you'd like to ask a question now, is indeed the time to do it. I do need to make my usual disclaimer before we get started, and that is that I am indeed an attorney, but I am not your attorney, at least not yet. Though for those of you in the audience today that are my clients, don't worry, you are still my clients. But for the rest of you that are not yet my clients, I am not your attorney, and today's event is not legal advice, does not create an attorney-client relationship, and of course is not a solicitation to offer legal advice. And so with that, let's get to the questions. First of all, this was a question that came in, I believe, in the comments to today's session. Do you see a path towards licenses for venues that sell both cannabis and alcohol? So in the near term, and perhaps probably the medium term, the answer to that is no. I do not see a path towards that. In fact, it's very clear in MRTA that the Cannabis Control Board is not going to allow organizations to have cannabis and alcohol within the same facility. Now, I did notice that there is a question that just came in that can you be a liquor license? And all the questions are coming in fast and furious, so let me scroll back up to it. Can you be a liquor license applicant and apply for a cannabis license? Now, those are two different things. So yes, I do believe that if you are currently a liquor license holder, that you would be able to apply for a cannabis license, but you would not be able to operate those businesses within the same physical space. You would not be able to have your liquor business sell cannabis, and you would not be able to allow your cannabis license to sell alcohol. And I think this really makes a lot of sense. Now, let's be fair. Have I ever had a blunt and then drunk a 40 or had a couple of shots or maybe a glass of wine? Of course I have. As well, I'm sure many, if not most of you that like to consume cannabis on today's call have also done. And I think you also probably noticed that when you both consumed cannabis and then consumed alcohol, the effects were double, if not more. It really impacted your ability to certainly drive, and we want no one driving when they are under the influence of cannabis or alcohol. But it probably also impacted your ability just to have a conversation with people. So for those reasons, I don't think the state is going to be terribly excited about there being alcohol and cannabis in the same storefront. Now, again, certainly people are going to be able to go to cannabis lounges, and I'm sure there are going to be dab bars in the city where people are going to dab really pure extracts of THC, and that's going to significantly impact them. And people can go to bars and drink 3, 4, 5, 6 beers, 7 beers sometimes, and be really impacted by that. But I do think you see that when you mix the cannabis and the alcohol together, smoking a pre-roll and having 1 beer or 2, or maybe a beer or 2 would not impact you significantly. Adding the pre-roll on top of that really could impact your ability just to function. So I don't think the state in the near or medium term is going to allow venues that sell both cannabis and alcohol. And frankly, it would not surprise me if that is not something that is ever allowed within the state, to have venues where both of those substances are available to consumers within the same physical space. Excuse me. All right, let's move on to another question that came in through some of the comments. And I believe the next two questions I'm going to answer came in immediately before the session. So thank you for that question, for the person that asked that. Can social equity applicants who have been convicted of past cannabis offenses opt out of the grant program and try to secure their space and still get priority? So I do want to unpack something here, some verbiage that is getting used that I think is a little bit confusing vis-a-vis social and economic equity applicants and justice-involved individuals. So this question is focusing on the conditional adult use retail dispensary license, which I do think we are going to hear from the Cannabis Control Board relatively soon about the fact that they are probably going to extend the regulatory review period for another 45 days. So that is a license that is going to be very front and center to a lot of folks here over the next 2 months or so. I do think that it's reasonable to expect that we will see that license application. My guesses would be right after the Labor Day holiday, maybe a little before, although as you know, folks don't really like to do things right before the Labor Day holiday. So I would think sometime in the month of September, we are very likely to see that application become available. It is indeed the justice-involved individuals that are eligible for that conditional adult use retail dispensary license. These are individuals that were convicted of a cannabis offense in the state of New York prior to March 31st, 2021, and who also can demonstrate 10% ownership of a business that was profitable for 2 years. So those are the individuals that are going to have priority for that, and in fact, exclusivity on that first initial conditional adult retail dispensary license. And for those individuals, if they want to apply for that license, at least as it appears now under the draft regulation that the Cannabis Control Board has promulgated, they will not be able to opt out. If DASNY wants them in their spaces, it is going to be a requirement that those individuals locate their business in the DASNY spaces. DASNY is the entity that will be spooling up and renting the state-created dispensaries. So as it says in the current draft regulation, those licensees, if the fund, and that is the fund that DASNY is receiving to be or creating to lease or buy the properties and then upfit those properties as cannabis dispensaries, if the fund wishes those applicants to enter into a lease for those facilities, the applicant is required to. As the regulation is currently written, there is no possibility for those applicants to opt out of, if DASNY wants you in their spaces, you must be in their spaces. Now, I do, again, want to make the distinction between those justice-involved individuals who are able to get that very first initial license and social and economic equity applicants generally. When it comes to the other 9 standard licenses that are going to be available under MRTA, perhaps 10 if you want to include the labs, and now perhaps even more if we want to include the conditional cultivation and the conditional processor license, which is now available. There are going to be many, many benefits to the social and economic equity applicants. They are most likely going to get priority under the review process. So when you look at the criteria which are to be used to determine if an applicant is to receive a license, the number one criterion, that is the very first one listed in the law, is the applicant a social and economic equity applicant? So clearly, for the standard licenses, the social and economic equity applicants will still have priority. I do think that the state is going to separate their applications into 2 piles, those that are social and economic equity applicants and those that are not. And it is quite likely that those that are social and economic equity applicants are going to get their applications reviewed first, or at least the first batches that come in. Additionally, there's all kinds of other benefits for social and economic equity applicants. We're talking about um, social and economic equity applicants are targeted to get 50% of the licenses. Social and economic equity applicants are going to have reduced or waived licensing fees. Social and economic equity applicants are going to be able to get low or no interest loans for their businesses. Social and economic equity applicants are going to be able to participate in the incubators to learn a lot about running cannabis businesses. Social and economic equity applicants are not going to have a right to property when they apply. They only are going to have a plan to get a right to property when they apply for their license. So again, it's very important that we make that differentiation between the justice involved individuals that are eligible for this very first conditional adult use retail dispensary license versus the normal social and economic equity applicants who are going to have a plethora of benefits when it comes to the standard licenses. All right. Next question. I'm going to do one that came in today. Is hydrocarbon extraction allowed in New York, or when will it? It does appear that hydrocarbon extraction is going to be allowed in New York. If you look at the fact sheet and perhaps more importantly, the terms and conditions that were released by the Office of Cannabis Management related to the conditional processor, and the license for that just opened yesterday, it does talk about the various methods of extraction. Whether or not you can get the conditional processor license, you have to have been a processor in the state's hemp program previously. And for the processors, you either got a license that allowed extraction or a license that didn't allow extraction. It'll be the same for the conditional adult use processing license. And then within that, there are various rules about the different types of extraction and the things you have to do. And if memory serves me correctly, the hydrocarbon extraction will be allowed, but you're going to have to demonstrate some environmental certifications and other things to show that you are doing it properly and that you are doing it in a way that harms the environment as little as possible, and that you are using best practices to be able to do that hydrocarbon extraction. So take a look at some of the rules that were promulgated along with that conditional adult use processor license, and that'll help give you some insight into the different types of extraction that the state is saying will be allowed, and what are some of the rules and regulations around those types of extraction. All right, so another question. How much equity can you hold on a dispensary license for it to not count toward the 3 dispensary license limit? I have to be honest, I'm not exactly sure what that question is asking. I think perhaps it is saying, if I'm an equity holder in one entity that holds some cannabis dispensary licenses, how low does my threshold have to be to not have it count against me being able to hold an economic interest in an entity that holds other dispensary licenses? And for that, the amount for it not to count is, at least from my understanding of where the CCB is heading, is 0. It is very clear in MRTA that the state has a vested interest in limiting how many licenses any one individual or entity has an economic interest in. And that is very dissimilar to how many other states have handled it. Many other states allow an entity to have dozens or more licenses. You've got entities that hold a huge number of dispensary licenses in a variety of states. And one of the things that New York, or I should say that the legislature was very concerned about in MRTA when they passed it, was making sure that you would not see lots of multi-state operators or MSOs come into New York and entirely dominate the state. So they really set a very draconian threshold for your ability to have an economic interest in an entity that holds licenses. So at least as we can tell at this point, at least without any further regulation from the Cannabis Control Board, you will only be able to have an economic license if you're doing it in an upstream license, if you've attended one of my sessions before and are familiar with what the upstream licenses are, you'll be able to only have an economic interest in one cultivation license. Now, if you get a cultivation license, you can then get one processing license and one distribution license of the cannabis which you cultivated. Similarly, you can only have an economic interest in one processing license, but you will also be able to get one distribution license of the cannabis which you processed. And you'd only be able to have an economic interest in one distribution license. And then similarly, on the downstream licenses, you'd only be able to have an economic interest in one entity that held between 1 and 3 dispensary licenses, or, and it is very important, it is or 1 to 3 on-site consumption licenses. Similarly, you can only hold one delivery license in New York. So the threshold for that, it does look like, is going to be 0. It is going to count even if you only hold one share in an entity. I think the state is simply going to have no tolerance for entities holding multiple licenses the way they do in other states, such that one organization could come to dominate the cannabis industry in New York. All right, let's go to a few questions from, let's see, previous questions. All right, let me roll up here. Do you know anything about the residency requirements and limitations for out-of-state investors? And yes, I do. I know a few things about the residency requirements and limitations for out-of-state investors. And I would like to unpack that issue a little bit bigger picture. It is a fascinating issue, and there's actually some litigation going on right now in other states related to residency requirements. So I'm going to start there, and then we'll get more specific to New York in particular. So Maine had some residency requirements in its medical marijuana program. And the residency requirement was that you had to be a Maine resident to be able to apply for that. And so a variety of out-of-state individuals sued in district court, and they won. The court ruled that Maine's residency requirement is unconstitutional. That is currently under appeal to the Second Circuit, I believe it is. And if you listen to the arguments, it seems like the judges are not impressed with Maine's argument about the necessity of a residency requirement. So I think the Second Circuit is going to similarly rule that Maine's residency requirement is unconstitutional. Now, why is that the case? Which is a fascinating question. And frankly, it also has very much to do with whether or not cannabis can be transported between states. If you know anything about that, it is actually legislation that each state has passed as to why there cannot be cannabis transported across states. Now, I know everyone's going to say interstate commerce clause and won't the feds freak out? And let me be very clear. Everything that is happening in the multi-billion-dollar cannabis industry in the United States is 100% illegal as far as the federal government is concerned. Yet there really has not been a tremendous crackdown, or for that matter, much of any crackdown on the part of the federal government on cannabis cultivators, processors, distributors, and dispensaries. I mean, yes, you've seen some folks, have the sheriff show up when they haven't paid some tax bills and some other things. But really, compared to what the federal government could do, they have done almost nothing. So it's not clear to me that the federal government would lay a heavy hand on cannabis going in between states. In fact, it is every state legislation piece of legislation that prevents the movement of cannabis between states. If you look at MRTA here in New York, it is in MRTA where it very specifically says the cannabis has to be grown and processed and everything else here in the state of New York that is preventing cannabis coming into the state of New York. So what is relevant in both that moving cannabis between states as well as those residency issues is something that is known as the Dormant Commerce Clause. So it is relevant to this Interstate Commerce Clause, which everybody is very familiar with. The Interstate Commerce Clause is a clause in the Constitution, which is basically what the federal government hangs its hat on pretty much to regulate everything they do in the United States, right? Pretty much everything has something to do with moving between states or moving a product between states, or a product where different pieces of that product were manufactured in different states and then moved between states in order to get manufactured in its completeness. It is indeed this interstate commerce clause that the federal government hangs its hat on to do most of the regulation that they do. So what that means is that this interstate commerce is within the domain of the federal government, and that the states do not have the right to regulate interstate commerce. So the dormant commerce clause becomes non-dormant when a state passes a law that in some way would impact interstate commerce. And I think, as you could see, this idea of out-of-state investors and out-of-state participants being able to be involved in a state's cannabis program and restricting it only to residents from within that state is infringing in some way on interstate commerce. So I think that is why you are finding that the federal courts are not lending a sympathetic ear to Maine's argument that Maine needs to have these residency requirements. And I do think you're going to see things like that continue. So here in New York specifically, there are no residency requirements as far as being able to get a license. There are various safe harbors that your business can do or that the entity that you are part of can do to make itself eligible to get a cannabis license here in New York. I'll mention two of them. One of them is that the entity that is going to get the license in New York is incorporated in New York. And the other is that a majority of your shareholders or stockholders are residents of the state of New York. Now, for my money, that safe harbor of incorporating your company in the state of New York is the real safe harbor. That's the best one, because you simply incorporate your business in the state of New York, and that's it. You don't ever have to worry about anything else. If you're going to hang your hat on the fact that the majority of your shareholders are in the state of New York, you then run the risk of, what if, let's say you have 3 shareholders and 2 of them live in New York, and one of them decides, I'm tired of the New York winters, I want to move to Florida. So they move to Florida, and now all of a sudden you're a Delaware corporation with 1/3 of its stockholders in the state of New York, and you are now in violation of the way your business is eligible to hold a cannabis license in the state of New York. So I don't recommend proceeding along those lines. I think the safe harbor of incorporating your business in New York is the better safe harbor. Now, you're going to run across some attorneys that say we only incorporate businesses in Delaware, and I'm sure most people have heard about that. There's certainly very good reasons to incorporate in Delaware. I just think the safe harbor of incorporating in New York, if you want to have a New York cannabis license, is a good way to go. But of course, me saying that is not legal advice to you. If you are getting a cannabis license and you need to figure out where your business is incorporated, you absolutely need to hire your own legal counsel and figure that out. You're welcome to hire me to do that if you want. But again, this is something your legal counsel will advise you on. But this is by and large how it's playing out. And that indeed, as the questioner asked, there is no residency requirement in New York. All right, let's go next to one of the questions today. Hi, Jeffrey. Hello, Chris. I spoke to a client in New York that mentioned they have 49% ownership in a cannabis license. How does fractional ownership in a license work? Does a fractional owner have the full rights of a normal owner? So my guess is that your client does not have 49% ownership in a license. They have 49% ownership in an entity, a corporation or a LLC, and the corporation owns 100% of said license. So owning 49% of that company, it's a very nice stake. If that entity is applying as a social and economic equity applicant, then one or more social and economic equity individuals better own that other 51%, because you must own at least 51%. 51% ownership by social and economic equity applicants in order for you to be able to apply as a social and economic equity applicant. 49% does not give you absolute rights over controlling the company. And as we know from MRTA, if you are involved with social and economic equity applicants, they must indeed exercise control over the entity. So that's why they must have that 51% interest. So, it's very normal for all kinds of organizations to have a variety of different ownership stakes. Certainly, a 49% ownership gives you whatever rights have been given to you by your shareholder agreement within that organization. Again, it's not an absolute majority, so that group cannot absolutely control the entity if the people that hold 51%, and that could be 51% among a number of people, but if they all agree to vote a different way than your 49% holder, the 51% are going to win the day. But otherwise, as a shareholder, you would have all the other rights that you would enjoy as a shareholder, and whatever rights are given to you vis-a-vis the shareholder agreement in the entity which you are a shareholder. And this is why shareholder agreements are so important, because they dictate the rights of the shareholders. Now, if no one other individual controls the 51%, then obviously it's going to be much easier for you to convince someone that owns 2% or 4% or 10% to vote with you rather than getting the other 51% to agree, right? So you're in a very good position. One interesting way that I always liked to make the example to folks, and this was explained to me in law school, and I never really had thought about it until it was explained to me this way. So let's say you have an entity where one person owns 49%, one person owns 48%, and one person owns 3%. What is the power dynamic within that company? And the answer is the power dynamic in that company is equal. Each person has a third of the power in the company, even though the person that owns 3% only owns 3%. And why is it that the power dynamic there is equal, a third, a third, a third? And the reason is because each of those three people only needs to convince one of the other two people to vote with them in order to win the day, right? So if the 3% person convinces the 49% person to vote with them, they win. And if the 3% person convinces the 48% person to vote with them, they win. And it's the same thing for the 49 person and the 48% person. Each of the three people in the company must convince one of the other two people to vote with them in order to win the day. So it's a very fascinating way to look at the power dynamic within the company when you're splitting up your shares and what the share structure is going to look at within the company. All right, it's 4:47. We're going to do one more question, and then we're going to wrap it up for the day. I saw that a large venue, several thousand square feet, must be procured and inspected before a dispensary license can be given. I read on further about the restrictions in advertising. How could I develop a plan with so many restrictions? All right, so for the first part of that question, what the person is referencing, on one of my posts on LinkedIn the other day, I presented part of the RFP that DASNY put out to the design build partner they're going to hire to build the dispensaries for the justice involved individuals, those first 150, 200 dispensaries that are going to be in the state. And as part of the RFP, they put out what I believe was about an 8-page document that said, for your response to our RFP, this is roughly what we want our dispensaries to look like. And they gave some size requirements, some infrastructure requirements, some upfit requirements. And I think that's just a wonderful document if you're going to want to be in the dispensary business in New York for you to look at and use as a guide. Now, are all dispensaries in New York going to be the 3,000 to 5,000 square feet that they talk about in that document? No, they are not. I want everyone to understand that that document that DASNY put along with the RFP, that is not going to be the requirement for every dispensary in the state of New York. I think there will certainly be 1,000 square foot dispensaries. I think it's possible here in New York City, where rents are incredibly expensive, that you may even see 500 or 800 square foot dispensaries. So I don't want you to look at everything that you see in that DASNY document as these are must-have requirements for my dispensary if I'm going to want to get my own space and build out my own dispensary. I simply think it's a very good blueprint. It shows you what DASNY is thinking about. I do think some of the things in that document will be requirements, but I don't think the 3,000 square foot size is going to be a requirement. But again, I do think this is a really good document to look at, to use as a blueprint, and to help you get your head around, okay, this is what DASNY is going to want to see in their dispensaries. So this is going to be a good starting point for me to think about what should I have in my dispensary. Now, as far as the advertising restrictions, the question asker is 100% correct. The questions that DASNY presented, the advertising restrictions that DASNY presented are incredibly draconian. I was quite surprised, frankly, at how draconian the restrictions are. Now, we are currently in, or shortly will be in, the public comment period, the first 60-day public comment period about those draft regulations. And I'm sure the advertising industry, heck, the advertising industry here in the United States is based on Madison Avenue. And I think we're going to be hearing a lot from those folks about comments about how draconian the regulations are. I really want to see the words sticky buds and stoner and chronic in the advertising that I see for cannabis brands. So it makes me very unhappy that the Cannabis Control Board is proposing restricting those words. I actually wrote a post on LinkedIn comparing their, the 5 words that they listed. And it's not just those 5 words. Those are just the 5 words that they specified. Comparing it to a comedy routine that George Carlin did. Many of you who know George Carlin, and for those of you who don't know George Carlin, as soon as you hang up from today's session, go and look up George Carlin and look up his routine, 7 dirty words that you can't say on television. This routine of his actually led to a Supreme Court case where the Supreme Court case ruled and said, no, the FCC can actually rule that you can't say these 7 words and a bunch of other words on television. But so these advertising requirements are very draconian. So number one, I think if you're a First Amendment lawyer listening today, I would encourage you to think about filing a suit to make it so that those 5 words can be on cannabis advertising. It seems to me that's a pretty winnable First Amendment case. And similarly, I do think there will be some modifications towards those advertising regulations. But I do think there will be a lot of restrictions. And I think the biggest one you're going to have to look for is you're really going to need to make sure that the audiences that you're advertising to are 21 or over. I think the threshold in the proposed regulation is 90% of your audience. And you're going to have to prove it. And it's going to be on the advertiser, you that paid for the advertising, to prove that the audience for that advertising was over 90% 21 plus. That is the highest threshold I think I've seen in any regulation. I believe California's is a very weird number in the low 70s. It was like 71.83, and maybe I'm misremembering it, but I just recall it being a very weird number. But obviously 90% here in New York is a crazy high number. So you really are going to need to be very strategic. You're going to need a very good attorney to help you walk through what is allowed. And you're going to need to be very creative when it comes to your advertising about how you go about in doing this. I do think there is going to be some good advertising available, but you're just going to need to be very careful about how you go about doing it. All right, we ran a little long today, but no harm, no foul. I do want to thank everyone for joining today. Just a reminder, we do this every Wednesday at 4:20 p.m. New York City time. So you are welcome to make this a regular occurrence. Again, if you're not currently a connection of mine on LinkedIn, please reach out and send me a connection request. Be happy to connect with you. And lastly, as I say every week, I know we're all very excited about the forthcoming cannabis industry here in New York, but we need to make sure that we are educating everyone that was convicted of a cannabis offense, that they can get their offense, that they can get that offense expunged from their record. We also need to get all of the non-violent cannabis offenders out of jail. A state which profits from an activity for which it is incarcerating people is committing a crime against humanity, and we can't have the state of New York gaining hundreds of millions of dollars in tax revenue while it's incarcerating non-violent cannabis offenders. So that's something I'm going to be working on over the coming weeks and months. and it's something that I want to make sure everybody is familiar with, and that you are talking to your elected officials to make sure that you will not stand for the state incarcerating nonviolent cannabis offenders while the state is profiting from the sale of cannabis. Thank you very much. I hope to see everyone next week, and I hope you have a great afternoon and a great rest to your week. Have a good one, everybody.